Picture a Friday evening in 1965. A man leaves the pub after 3 or 4 pints, climbs behind the wheel of his car, and drives home with the windows cracked open to let the cigarette smoke escape. His son is standing on the back seat, bracing himself against the front headrest every time the car turns a corner, while the man himself has a cigarette burning between 2 fingers on the steering wheel hand. Nobody in that car is wearing a seatbelt. Nobody thinks twice about any of it. That was just a Friday. That was just how you got home. The radio is playing something from the top of the charts. The ashtray built into the dashboard is already overflowing. And when they pull up outside the house, nobody rushes to unclip anything, because there is nothing to unclip. The front door of the house is probably unlocked too, because half the street left their doors unlocked back then, and nobody thought that was worth mentioning either. If you tried any part of that today, you would not make it to the end of your street before someone called the police. And that is really the whole point of this video. We are going back into the everyday texture of British life in the 1960s, and we are going to look honestly and without flinching at the things people did without a second thought. Things that were completely ordinary, completely respectable, completely legal, that would now get you handcuffed, fined, or dragged in front of a magistrate. Some of what follows will make you laugh. Some of it will make you shake your head in disbelief. And one part of it, right in the middle of this video, is going to be genuinely hard to sit with. Stay with it, because by the end you will understand something important about how quickly a society's idea of normal can shift, and how much of what your parents or grandparents lived through has simply been erased from popular memory. Let's start with the drink driving, because it sets the tone for everything else. In 1965, there was no legal blood alcohol limit in the United Kingdom at all. None whatsoever. The breathalyzer, the little device police now use at the roadside to test your breath in seconds, did not yet exist as a legal tool. A driver could be stopped by a police constable, could be visibly unsteady on their feet, could smell of whiskey from across the car park, and unless a doctor was specifically called to examine them and formally declare them medically unfit to drive, there was very little the police could actually do to stop them getting back in the car. Pub culture and driving culture were, in a very real sense, the same culture. Men drove themselves home from the darts match, from the working men's club, from a wedding reception, and their wives sat quietly in the passenger seat because there was nothing unusual about any of it to comment on. That began to change with the Road Safety Act of 1967. For the first time, Parliament set an actual legal limit on blood alcohol content and gave police the statutory power to administer a breath test at the roadside without needing a doctor present. It was, at the time, genuinely controversial. Newspapers ran satirical cartoons mocking what they called the new breathalyzer law. Publicans warned it would ruin their evening trade. Some drivers treated the early roadside tests almost as a joke, a minor inconvenience to be talked or charmed your way out of. But the number of road deaths linked to alcohol began falling almost immediately after the act came into force, and within a handful of years, drink driving went from being, at worst, a slightly embarrassing habit among friends, to a criminal offense that could put you in a police cell overnight and take your license away for a year or more. If you had told that 1965 driver 3 pints deep and pulling confidently out of the pub car park, that within his own lifetime he would be facing a criminal record and a mandatory driving ban for doing exactly what he was doing at that exact moment, he almost certainly would have laughed in your face. Now let's talk about something far less funny and far more revealing about what normal genuinely meant in that decade. Walk down a residential street in parts of London, Birmingham, or Bristol in the early 1960s, and it was entirely legal and depressingly common to see handwritten cards propped in the windows of boarding houses that read, in plain, unapologetic language, "No blacks, no Irish, no dogs." These were not underground signs hidden from public view or whispered about behind closed doors. They were displayed openly in the front windows of ordinary terraced houses, advertising rooms to let, right alongside the price and the mention of whether breakfast was included. Job advertisements in local newspapers openly specified racial and national preference. An employer could reject an applicant on the spot, in writing, in plain black and white, simply for being black, or Irish, or newly arrived from the Caribbean, and there was no law in the country standing in the way of it. West Indian men and women who had been actively invited to Britain to fill severe post-war labour shortages, on London buses, in hospitals, in factories, frequently discovered that the invitation to come and work did not come with any invitation to be treated as equals in housing, in the pub down the road, or on the shop floor. The turning point arrived, gradually and imperfectly, with the Race Relations Act of 1965, followed by a considerably stronger act in 1968. The first version was limited in scope, addressing discrimination mainly in certain public places like restaurants and cinemas, but the 1968 Act extended the law directly into housing and employment, the two areas where discrimination had been most brazen and most damaging. Long for the first time in British legal history, refusing someone a room to rent, or a job they were qualified for, explicitly because of their race, became something you could actually be taken to court over. It took years, honestly, for enforcement to catch up with what the law now said on paper, and prejudice obviously did not evaporate simply because Parliament had passed an act. But the legal shield that had allowed those handwritten window cards to hang without any consequence at all was for the first time gone. Today, that same sign in a landlord's front window would not just get the landlord an angry letter. It would very likely end up as documented evidence in a discrimination case under the Modern Equality Act of 2010, and it could cost that landlord their entire rental business. There is another layer to that same story worth pulling apart, because it concerns not what ordinary people could legally do to each other, but what the police could legally do to them. Under Section 4 of the Vagrancy Act of 1824, a piece of Victorian legislation originally written to deal with beggars and so-called vagabonds, a police officer in England and Wales had the power to stop, search and arrest someone purely on suspicion that they intended to commit a crime, without that person actually having done anything at all. No theft needed to occur, no violence needed to take place. A constable simply had to believe or claim to believe that a person was loitering with criminal intent, and that belief alone was enough to justify an arrest. Through the 1960s and well beyond, this power, informally known as the sus law, was used overwhelmingly and disproportionately against young black men, who could be stopped and detained repeatedly on their own street, on their way to work or back from a friend's house, for the simple offense of existing somewhere a police officer decided looked suspicious. It remained fully in force until it was finally repealed by the Criminal Attempts Act of 1981, following serious unrest in Brixton that made the law's discriminatory use impossible for the government to keep ignoring. A police officer who tried to arrest someone today using nothing more than a vague personal suspicion, with no evidence and no offense actually committed, would themselves be acting unlawfully, opening the force up to a legal challenge. The power itself, not just the people who once used it, would now be treated as the problem. Smoking deserves its own moment here too, because the sheer scale of it is genuinely difficult to picture today. In the 1960s, you could smoke absolutely anywhere. On the bus, upstairs and downstairs. In the cinema, with the blue haze visible in the projector beam. In the waiting room of your doctor's surgery. On the hospital ward, sometimes with the nurses smoking right alongside the patients. Cigarette advertising ran constantly on television, with confident actors and glamorous film stars lighting up on screen as though it were a form of medicine for the nerves, until the government finally banned cigarette adverts from British television on the 1st of August, 1965, one of the earliest cracks in the wall of unrestricted tobacco culture. Even after that ban, smoking itself remained completely unregulated in enclosed public spaces for another 4 decades. It was not until the comprehensive smoking ban of 2007 that lighting a cigarette inside a pub, an office, a train carriage, or a restaurant became a specific offense carrying a fine. A man in 1965 lighting up in a crowded waiting room, with children sitting nearby, was not breaking any law whatsoever. Today, that same act would see him issued a fixed penalty notice on the spot. Before we go any further, if you have lived through any of what we are describing, or if your own parents told you stories like these while you were growing up, I would genuinely love to hear it in the comments below this video. School discipline in 1965 was, by today's standards, a form of state-sanctioned violence against children, and almost nobody at the time saw it that way, or was permitted to see it that way. Corporal punishment in British state schools was completely unambiguously legal. A teacher could keep a cane in a cupboard at the front of the classroom, call a misbehaving pupil out to stand before their assembled classmates, and strike them across the palm of the hand or across the backside for offences as trivial as talking out of turn, arriving late, or failing to finish a piece of homework on time. Some head teachers kept a formal punishment book, a written ledger recording the name of every pupil caned, the date, and the reason given, almost like an accounting record of pain. Parents very rarely complained about any of this, because the overwhelming majority of them had been caned at school themselves as children, and saw it simply as an unremarkable, character-building part of growing up in Britain. A bit of firm discipline that never did anyone any lasting harm, or so the thinking of the time insisted. It took a remarkably, almost shockingly long time for this to actually change. Corporal punishment was not banned in state schools until the Education Act of 1986, and it remained fully legal in England and Wales's private fee-paying schools until 1998, with Scotland and Northern Ireland following only a little afterward. Sit with that gap for a second. A child born in 1960 could have been legally caned at school right up until they were an adult in their mid-20s, because the law protecting the next generation of children took that extraordinarily long to actually arrive on the statute books. Long. A teacher who struck a pupil with a cane today would not simply lose their job and their teaching qualification. They would very likely be facing criminal charges for assault, and quite possibly a custodial sentence. The classroom store cupboard that once held a length of rattan cane, propped casually next to the sports equipment, would today be treated as evidence in a criminal investigation. And it was not only the cane. Teachers routinely used a ruler across the knuckles, a firm slap on the back of the legs, or having a child stand facing a wall for an entire lesson as public humiliation, all treated as completely unremarkable classroom management. The sort of thing a child simply did not go home and complain about, because complaining would likely have earned them a second punishment at home for whatever they had done to deserve the first one at school. Firearms tell a strikingly similar story of a Britain that trusted ordinary citizens with far less formal oversight than we would recognize or accept now. Before the Firearms Act of 1968, buying a shotgun in Britain could be almost as straightforward as walking into a local ironmonger's shop or a small-town gunsmith and simply paying for it across the counter, with nothing resembling the rigorous licensing, police interviews and background checks that govern gun ownership today. Farmers, gamekeepers, and countryside hobbyists commonly kept a shotgun in the house the way another family might keep a set of golf clubs, propped casually in a hallway cupboard rather than locked away in a dedicated steel gun cabinet bolted permanently to an interior wall, which is now a strict legal requirement for anyone holding a certificate. Children traveling in cars deserve their own careful moment here, because it is one of the clearest, most visceral snapshots of just how much everyday domestic life has changed in Britain. There was no legal requirement for seat belts to even be fitted as standard in the front of new cars until 1967, and no legal requirement to actually wear one until much later, into the 1980s. Long before any of that legislation existed, it was entirely ordinary, entirely unremarkable, to see children standing upright on the back seat, kneeling backwards to peer out through the rear window at the road disappearing behind them, or piled 3 and 4 across a single bench seat with absolutely nothing physically holding any of them in place. Some families let children ride loose in the boot of an estate car on long summer journeys to the coast, treating the boot space essentially as an extra bit of luggage room that happened to have a heartbeat inside it. Car seats for infants, in anything resembling the form we would recognize and expect today, essentially did not exist as either a legal or a cultural expectation. A crash at even a modest speed could turn an unrestrained child into a projectile inside their own family car, and very few parents at the time had any real framework, medical or otherwise, for thinking about that specific risk in those explicit terms. Now compare all of that to today, where driving with a child unrestrained, without an age-appropriate and correctly fitted car seat or seatbelt, is a specific, clearly defined offence that brings fines and penalty points directly onto a parent's driving licence. Police forces across Britain now run entire dedicated road safety campaigns built around checking that child car seats have been fitted correctly before a journey even begins. The 1960s parent who let their child stand freely on the back seat on the short drive to the corner shop was not being cruel, careless, or negligent by the standards of their own time. They were being completely, unremarkably normal, doing exactly what every other parent on their street was doing. That is precisely what makes looking back at it now feel so quietly unsettling. There is one more thread we need to carefully pull before we reach the heaviest part of this entire video, and it concerns a freedom that had barely existed for long enough to feel secure by the time the 1960s were fully underway. For most of that decade's opening years, consensual sexual acts between men in England and Wales were still a serious criminal offence, carrying the very real, ever-present possibility of arrest, public prosecution, and imprisonment, regardless of consent or privacy. It was not until the Sexual Offences Act of 1967 that those specific acts were finally, partially decriminalised, and even then, only under narrow, carefully hedged conditions, between two men both over the age of 21, strictly in private, with the law continuing to apply far more harshly and punitively to anything considered to have occurred in public. Scotland would not see equivalent decriminalisation until 1980, and Northern Ireland not until 1982, meaning huge parts of the United Kingdom lived under the old, harsher law for well over a decade after England and Wales had moved on. So when people casually talk about the swinging 60s as though the entire decade was one long, unbroken party of liberation and free love, it is genuinely worth pausing to remember that for a substantial part of that same decade, simply loving someone privately, with their full and enthusiastic consent, could end your career, destroy your marriage, ruin your standing in your own community, and land you inside a prison cell. The 1967 Act was a genuine milestone, rightly celebrated to this day as a turning point, but it arrived squarely in the middle of the decade, not at its beginning, and it left enormous legal gaps that would take until well into the 21st century to fully close. What felt, to some people living through it at the time, like the start of a more open, tolerant Britain, felt to countless others like exactly the same closed, punishing country it had always been, only very slightly, cautiously less so. And now we arrive at the part of this video that is genuinely difficult to talk about, and I am not going to soften it, because softening it would do a real disservice to the people who actually lived through it in silence. For most of the 1960s, and for decades afterward, a husband could not, in the eyes of English law, be found guilty of raping his own wife. The legal reasoning behind this traced back centuries, resting on an old doctrine that the act of marriage itself constituted a form of ongoing, irrevocable, permanent consent, meaning that whatever happened within a marriage, however violent, however unwanted, however clearly refused in the moment, simply did not qualify as the crime of rape under the law as it then formally stood. A wife in 1965 had, in this specific and genuinely devastating legal sense, fewer protections inside the walls of her own home than a complete stranger would have had walking down her own street. This was not some obscure legal technicality that nobody at the time actually noticed or lived with. It directly shaped how police officers responded, or far more often simply did not respond at all, to desperate calls from distressed and frightened women. It shaped how courts, family doctors, and even a woman's own closest relatives treated her account of what had happened to her, in her own bedroom, in her own home, at the hands of her own husband. The language used at the time, on the rare occasions it was discussed at all, was often deliberately softened, carefully avoiding naming the act plainly, because the surrounding culture actively discouraged even the basic language of a crime being spoken aloud in polite company. It would take until 1991, in a landmark House of Lords ruling known simply as R against R, for English law to finally formally recognize that marriage does not, and legally cannot, function as a form of blanket, permanent, irrevocable consent. Parliament confirmed this recognition in statute a few years later. Until that ruling came down in the eyes of the law, whatever happened in that bedroom in 1965 simply was not a crime, no matter what had actually physically taken place within it. Sit with that for a moment, because it says something far larger and far more important than any single statistic ever could on its own. An entire generation of married British women lived through their most private suffering with genuinely no legal language available to them to even name it, formally, as a wrong that had been done to them. Today, marital rape is unambiguously, straightforwardly a criminal offence in this country, prosecuted with exactly the same seriousness as any other. The distance between 1965 and today, on this single specific issue, is not measured in changing fashion or advancing technology, the things this channel usually celebrates. It is measured starkly in whether the law recognized a woman's fundamental right to say no inside her own marriage. That particular gap did not close until 1991. We have covered a great deal of ground in this video, from drink driving with no legal limit whatsoever, to landlords openly hanging signs in their windows that would now be flatly illegal, from children caned across the hand in ordinary classrooms, to children standing unsecured in the back of moving cars, from a fragile, narrowly defined freedom for gay men to a devastating legal blind spot that left married women almost entirely unprotected for far too many decades. None of this is meant to make you feel superior to the people who actually lived through it, because they were not bad people simply for accepting the world they had been handed at birth. They were, almost without exception, simply living inside the only version of normal they had ever personally been offered. That is the genuinely uncomfortable truth sitting underneath every single one of these stories tonight. Normal is never fixed, never permanent, never as solid as it feels while you are living inside it. It is really just the name we give, at any given moment, to whatever we have not yet gotten around to questioning. If you grew up in that decade yourself, you already know things. This video has not even come close to touching on small everyday details that never made it into any official history book, the kind of detail that only survives because someone who was actually there chooses to pass it on. And that, honestly, is exactly what makes this community around this channel so genuinely special. So tell me honestly in the comments below, which one of these hit you the hardest tonight? The drink driving, the housing signs in the windows, the school cane, the children loose in the back of the car, or that last, heavier point about the law inside marriage? If this video gave you a clearer, more honest picture of the real Britain behind all the warm nostalgia, do one more small thing before you go. Subscribe to this channel so that you do not miss what we uncover next time. Give the video a like, it genuinely helps far more people discover this channel than you would guess. And if there is someone in your life who lived through 1965 and would have strong feelings about absolutely everything, send this video their way. Let them tell you, in the comments, exactly what we got right and what we still have not quite said. Thank you sincerely for watching all the way through, and I will see you in the next one.